Mr. Sharma, thank you very much for joining us and helping us break down that case with legal details. For now, viewers, let's move ahead. Senior Advocate and Rajya Sabha MP Abhishek Manu Singhvi is holding a press conference after Pawan Khera was granted anticipatory bail from the Supreme Court. Let's cut across.
हम ऐसा क्यों मानते हैं, इस पर और जानकारी मेरे वरिष्ठ साथी सांसद और हमारे देश के जाने माने वकील डॉक्टर अभिषेक मनु सिंघवी जी देंगे, आपको संबोधित करेंगे। डॉक्टर सिंघवी।
धन्यवाद जयराम जी। नमस्कार दोस्तों। एज यूजुअल इंग्लिश और हिंदी दोनों में करेंगे ब्रीफली। Let me start by telling you what this PC is not about. This PC is not to gloat, to exult, or to be self-congratulatory on this great victory. Instead, according to me, the purpose of this PC, on behalf of the Congress Party, is to remind ourselves first and foremost, that when personal liberty is an issue, citizens' liberty is an issue, the court is our ultimate bedrock of hope. Second, a lesson for all, including us. Be you ever so high, the law is above you. Third, to rededicate ourselves that if we have this faith and commitment to law, the law will protect us. It will not allow injustice to prevail. And I also want to make it clear that this is no comment on a sub judice case. The case is over, judgment has come. But I will still be, as I said, not here to exult or gloat or be self-congratulatory. I must remind you, for those of you who have forgotten perhaps, that this was a journey of steadfastness and continued faith in getting justice, which we thought is our due. Why? Because this journey has had, in a very short period of time, multiple stages, fora, places, positions. From the original magistrates' court, where the state went, in Assam, in Kamrup, to the transit bail court in the High Court of Telangana, to the Supreme Court, back to the High Court of Guwahati, and then finally to the Supreme Court, which has today delivered judgment. In this entire process, our unwavering faith and commitment in the judicial process can be seen. That of the litigant concerned, that of the Congress Party, and that of every other stakeholder. This case also reminds us that when reputational damage is an issue, the beginning of this case, the heart of this case is alleged reputational damage. So it reminds us that when that is the issue, arrest should not be the first, but the last resort. And a last resort on what test? Can you achieve the objects of proper investigation without arrest? Is arrest the only way I can investigate his alleged defamatory comment? Is arrest the only way because this case is bristling with flight risk, that if I do not arrest him and custodially interrogate him, he will flee? Arrest is the only way because I will not be able to summon him and sit with him and interrogate him without arrest. Arrest is the only way because he will tamper with documents or with witnesses. Lawyers call it the triple test. Now, on the face of it, when this test is not satisfied, let us assume there was an error, let us assume the right is this or the right is that. Irrespective of that, the press conference, which is alleged to have caused reputational damage, had everything in the public sphere, transparently. Documents were also transparently demonstrated or used. Well, in that case, clearly, if the triple test is satisfied in favor of the accused, then the only object of arrest, of custodial interrogation, especially in a political adversarial context, can be humiliation, harassment, scoring a political point. And that is the message both in the text and the spirit of this judgment. There is also a larger issue. And let me preface it by saying, I am nobody, and I mean it, to advise the Honorable CM of Assam. He may well head to a victory 2 days later, he may not. These are the vicissitudes of democracy and of politics. But I would, with folded hands, request the Honorable CM, presently perhaps a caretaker CM for 2 more days till the verdict comes out, that irrespective of the outcome on Monday, does he not wish that he should genuinely reconsider his stand as reflected in the judgment, quoted in the judgment? The statements made by him in public domain and quoted extensively by the Supreme Court over almost 3 pages in para 22. Most are unrepeatable, unprintable and unstatable. But you can all read it now. Even the Supreme Court has not reproduced what my petition reproduced. So I, with humility and without any condescension, would say that this truly debases our democracy. It devalues. It makes us no different from the constitutional wrecks and ruins which we find in our neighborhood. And I think unparliamentary language is the mildest word in the dictionary. But without asking him to reconsider or apologize, and I said, I'm nobody. If he were to do it and express regrets genuinely, he would actually be elevating himself. But the Supreme Court has categorically underlined those observations, only partially quoted. Those of you interested should see the real full text in the petition file, which are also in public domain. And the Supreme Court has underlined, this is important in case you missed it, that the Solicitor General neither justified nor supported those statements. The other brief points to make before I address you in Hindi briefly is that against the entire might of this state and against the absolute Rambo statements of the Honorable Chief Executive of that state, you must not forget that the state, the investigating officer, went with a non-bailable warrant, virtually amounting to an arrest warrant, to the lowest level in the judiciary, the magistrate in Kamrup. On 7th of April 2026, much before all this happened, 2 days after the press conference, the magistrate in Kamrup, the lowest level of the judiciary, gave a reasoned order recording every allegation and contention of the state government, gave reasons as to why the requirement and the claim to arrest is speculative, without foundation and fanciful. That is what we must also cherish in our judicial system. The other issue which you might want to note is that the judgment which was challenged by us in the Supreme Court, the last judgment of Guwahati High Court, added sections which were not in the complaint, not in the FIR, not raised by the complainant. They found their place in a judicial order which the Supreme Court has frowned upon in the judgment which has come today. Another thing you must note is that right for the last 30-40 years, and I don't want to bore you with technicality, the Supreme Court in a famous anticipatory bail case called Sibia said that ultimately when you look at a man who is approaching in anticipation for bail pre-arrest, you must not forget the presumption of innocence. If there is a presumption of innocence, that validates anticipatory bail more than anything else. That is reiterated in today's judgment. Another facet, every section in a hurry which could be thought of was thrown against this accused, Mr. Khera. We gave a chart pointing out that out of 10 or 11 sections, 9 were bailable offences. For those of you who don't understand, bailable offence means that you don't need to go to court for bail, even the police has the discretion to grant you bail. They are
All right, viewers, Congress